Hmm. Bonjour. I'm just trying to figure out how to connect with the other lawyers that I'm going live with. So just uno momento. Hmm.
Hey, Darren, can you hear me?
Hey, Charmaine, I can hear you.
I
Let's see
don't
if
know how I show up as a video. It gave me a notice saying that I would only show up as sound.
okay. There's got to be a way to do this.
And I don't mind just being sound, but it would be more fun to.
Yeah, no, we want the full meal deal here. We want the full meal deal here. Um, Sorry, folks. This is what you get when you get
When it's
lawyers.
live, anything is possible. But you can also ask your questions while we're figuring out our tech issues. And
Yeah.
I could leave and come back too if that's I don't know. Oh, here we go. Well, it says follow. Okay, well I think I'm already following you, but I'll refollow you. There you go.
Hmm. I'm sure Rob's trying to get in as well. This may be,
This may be the live with Darren as the focal point, but
there we go.
hey, everybody who's already on, that's okay, right? That's
Okay. I'm gonna click X, which I think will remove you. Let's try this again,
okay.
Charmaine.
Yeah, remove me, and I will try to hop back on. Okay.
Hey, Rob.
Hey, how are you?
Good.
I think it was on my end, Darren. Actually, I had some other button to click. So
Okay, now I can see you, Charmaine. Rob's connected, but I can't see you. Rob, is your video on?
I am figuring that out. This is like a Zoom call circa March 2020. Hello, we can see you, we can't hear you. What's going on?
That's exactly right.
Your mouth is moving. Oh Lord.
Yeah, get the cat filter on.
I think I need to leave, and one of you needs to re-invite me in. Sorry. Wow.
Okay, I'm gonna click you out, and then I'll get you back on. But in the meantime, we'll be waiting.
Yeah, we'll be here. So this is what I love about lives is that you just have to take us as you find us.
Indeed. Okay, are you? I'm getting tech advice from folks.
Okay. That's good. Well, as long as if as lawyers we're asked math questions or to deal with tech issues, that's not our strong suit. There you go.
Wow,
there we go.
Can see you too, Robert.
Wonderful to see you, Charmaine. Thank you for setting this up.
Yeah, well, thank you both for being interested. I thought it would be super fun because watching your videos and just thinking about how we're from these different jurisdictions and just getting different perspectives, because I think a lot of times people don't realize that the laws are different from province to province, but there are some overarching themes that are the same regardless where you're from. So I see one of the first comments here: thoughts on coercive control and post-separation abuse. Thoughts.
I'm not sure I have strong thoughts one way or the other on this.
It's bad. Both of those things are bad.
We condemn that, yes. But yeah, I think that might be. I mean, look, we have generally a no-fault divorce system, subject to our new tort of family violence out of Ontario, which seems to be an interest of many on this platform, but it's a no-fault divorce system, save for those issues of family violence that would affect one's ability to be a parent. Best interest factors would control that issue. So obviously family violence would be an important consideration for determining parenting time and parental decision-making, but post-separation misconduct, if you're being subjected to family violence, my first thought would be phone the police and see if they can sort it out. And secondly, phone your Child Protective Services Agency to have those folks help you out. Because the less you can litigate about parenting time, the better, I think. But what do you guys think?
Well, what I'll chime in on, and then interested in your thoughts too, Robert, is that in my experience, some of the coercive control and post-separation abuse presents itself in manipulation of the process, whatever the process the parties might be engaged in. So whether that's the litigation process, there's all sorts of ways to really make that even more difficult than it is at face value. So asking for multiple adjournments, just continually bringing applications, it's just nonstop. And then, of course, if you're in any other type of out-of-court process, there's concerns about manipulation as well, and honesty and transparency. I mean, my opinion, though, is that somebody who's not going to be honest or transparent in a mediation or collaborative process isn't going to be in a court process either. They don't necessarily have some sort of automatic respect for the fact that it's a sworn document or that a judge is going to look at it. Bill Eddy is somebody that I really think does a great job of writing about these issues in a way that's very practical. He even has a chart that's like, hey, you don't have to worry about whether your ex is diagnosed as a narcissist or bipolar or histrionic, but if they're demonstrating these qualities, these high conflict qualities, then they're demonstrating those same characteristics that they may or may not be diagnosable. But let's talk about, what are some practical things you can do to be able to manage those dynamics. So for the person who's wondering about coercive control and post-separation abuse, yes, there you go, high conflict people, Bill Eddy, and he has some other great books as well on communication skills, and he has courses. So that's kind of my go-to on that. Robert?
My view is very much the same as Darren said and as you suggested. I mean, people come through challenging relationships. The most important thing, and litigation can be tough. And the process of getting divorced, as we all know, it is not cheap and it is not easy, usually no matter who comes to see us. And the most important part, can we get you separate and apart? Can we make sure everyone is safe? And how can we get you to a place that you can move forward? And as you suggested, Charmaine, easier said than done. But that's our goal, whether tort of family violence, whether we're formally considering those coercion and control pieces. How can we get everybody forward?
Mm-hmm. And I think the other thing that's important to remember is that lawyers and the law have very limited abilities to deal with some of those things. So if it is criminal, that the criminal law regime is the place to seek the protections and the consequences of people committing crimes. When it comes to actual family separation and divorce procedural things and making decisions, I think in addition to having an awesome lawyer that's trauma informed, it's important to also have a trauma informed counselor and to have child specialists if you have children and you're concerned about the impact on them, and to even have a financial expert that is able to help you put your mind to what your financial needs are and the ways in which dividing your family property will impact you short term and long term. So it's not just about having an awesome lawyer, though that's certainly step one. But you need to have a team of people that can help you when there are those other dynamics in place.
I think I think we're getting some questions around that, but one thing I think, so people are probably thinking, well, if I can I go to court to make my ex-spouse stop being a jerk? Which, I mean, the answer is no. But one thing I'm interested in, Charmaine, because Rob and I have had a lot of discussions about this, how we now go to court and how we have gone to court, if we go to court, through the pandemic has mostly been digital. And so I'm curious what Saskatchewan's doing, because BC and Alberta, Rob's in Alberta, I'm in BC, and here's the big reveal. Rob and I would both say we are unfortunately headed back to in-person court appearances. But curious what's going on in Saskatchewan, but I won't pry for your opinion on that point, but I'm just curious what's going on.
I'm okay with giving my opinion too on things, but I can say, same thing in Saskatchewan. Our experience was that our court actually shut down entirely, wouldn't even do anything for approximately 3 months, which you can imagine caused all sorts of chaos. And then when it did open, it was only for virtual appearances, and now it is embracing a bit of a hybrid model. Still, we have a number of our judiciary who are still quite concerned about COVID and risks, and so there's still sometimes the judges themselves are asking for it to be virtual, and counsel is still allowed to make that request. And I can't speak from firsthand experience because I do not do any litigation. I only do collaborative law and mediation, all settlement outside of court-based work.
I want that.
Yes, well, you put it in your name. I'm Panko Collaborative Law and Mediation, which means I really don't get any calls from people who are looking to litigate. Now, of course, I sometimes get calls from somebody who really wants to be able to deal with their matter outside of court, but the other side it doesn't come along, right? And so in those instances, my role is still, I think, very important because I can help the client retain litigation counsel, but I can still giving them some assistance in terms of the process and thinking through keeping their needs and interests foremost, even as they're making decisions about their court applications going forward.
Right. I would think in a province like Saskatchewan, like other provinces, but I think in particular Saskatchewan, the notion of virtual court appearances would be excellent, because I'm going to guess most of the filings happen either in Regina or Saskatoon. There's obviously Queen's Bench and provincial court outposts outside of that, Swift Current, elsewhere, right? But there's probably a lot of folks that live in remote parts of the province and go, it's awfully nice to be able to Skype in or MS Teams in to those court appearances if I need to do it, rather than driving 6 hours into a major judicial center to have my matter run.
Yeah, I mean, everything comes with pros and cons, right? It's in Saskatchewan, we have lots of remote communities, but those remote communities don't necessarily have Wi-Fi. So there were people that, certainly benefited out of rural communities to be able to attend virtually, but others that then lost entire access to justice options because there was nothing in person, and they didn't have the ability to attend virtually either unless they traveled somewhere in any event. And of course, we've seen, I think all of us through various different social media platforms, some of the funny things that have happened through virtual appearances. Of course, there was the whole Amber Heard Johnny Depp trial, like, some of those witnesses appearing, driving in their vehicle, that kind of thing. And so we have some of entertaining stories like that out of Saskatchewan too, where it's like when people don't have to get up, get dressed, and go to court, where there's this air of formality, the ways in which the tenor of the whole court proceedings really changes. And, there's a different feeling, like it doesn't have the same level of respect in some cases, not for everybody, but there have been some instances of, people appearing from their head on their pillow and they're just rubbing the sleep out of their eyes too.
Okay, here's a question from Cassia. What happens when you can't agree on a separation date? This might be one where you do need to tender evidence at court about what that separation agreement is if you can't land on the date. But Rob, any thoughts on that?
Yeah, I'd agree. Separation date can be really important for a whole host of reasons. Number one, valuing potentially assets and tax consequences after the fact. If you can't agree, you're likely headed for a hearing because a judge will need to make that decision on either sworn or verbal evidence from you.
Yeah, so you have to determine whether the juice is worth the squeeze or whether you're just fighting for the sake of fighting, and it's a source of pride on that date. So, what are your experiences, and I have none with this, with an arbitration to settle a divorce? Charmaine, do you act as an arbitrator?
I do, yes. And in fact, Saskatchewan recently implemented legislation that's currently mandatory in 2 of our judicial centers. So for those of you who are joining us from Saskatchewan, you'll know the Judicial Center of Regina, Judicial Center of Prince Albert. For the rest of you, it won't mean anything to you, but you could look it up on a map if you wanted. It will soon be mandatory across the province, but these mandatory provisions will require families to participate in an early dispute resolution process prior to being allowed to bring an application to court. And one of the dispute resolution processes that's been identified is arbitration as one of them. So arbitration is arguably still a very new option for family law matters here in Saskatchewan, and it has not, to the best of my knowledge, there haven't been a lot of arbitrated cases yet. However, some of the real advantages to it, of course, is your ability to choose who your decision maker is going to be. In Saskatchewan, we have a small judiciary, and they move around, so we don't necessarily have, you can appear in court before somebody who's a bankruptcy judge primarily. And they wouldn't necessarily know much about family systems or the needs of children. And they're still, and I'm in no way being disparaging to the court here, but the recognition of the fact that you don't know who is going to be deciding your case, where in arbitration you have the ability to, and if you think about, if you say you own a family business, and it would be really helpful to have somebody make the decision on how to divide your family property that has business acumen, you're able to find a family arbitrator who has that background and expertise, rather than the possibility that the judge who might be well experienced regularly in family court but didn't have that background related to family business and the division of property. So arbitration allows you the ability to handpick your decision maker, and it also allows you the ability to work out a schedule that might be more conducive to your needs. Right now, and I'm interested in your jurisdictions, what your waiting list is like, but in order to have, to get to a trial, there's easy, 6 months to 1 year to wait. And if you are hiring a private arbitrator, it doesn't mean that they're going to be available tomorrow necessarily, but they are likely going to be available sooner than you could get to a trial. And they will also, by contract, commit to when you'll get their decision, when they'll issue their award. Whereas I have had instances prior to now I don't go to court, but where we've waited for 2 years before getting a decision. So, yeah, and that's totally outside of your control. You just have to wait. What are the timelines like in your jurisdictions, Robert and Darren?
Go ahead, Darren.
So in BC, we have in our Supreme Court, our superior level court, we call it Supreme Court, which I think is confusing. I like Queen's Bench. I hail originally from Alberta, but any family case filed in Supreme Court, you must first complete what's called the Judicial Case Conference. So it's our classification of a judicial mediation. And you can't opt into something else in lieu of that. You must complete the Judicial Case Conference, and you must do that before bringing any interim applications at all. So unless it's an emergency, basically to jump the queue out of the JCC process, you have to have a protection order matter, a relocation matter, or something really urgent that would necessitate the court's attention on an immediate basis. In Vernon, where I am, in the North Okanagan, the wait times from filing your divorce proceeding or your family law proceeding in Supreme Court to scheduling a judicial case conference right now, the earliest date I can get for a judicial case conference in Vernon is in December of this year. So that would mean no interim applications between now and December, subject to getting court approval, which is good in a way. And I think coming from Alberta, Rob and I both used to practice in Fort McMurray, and we experienced what we call the Fort McMurray special, which is Fort McMurray Chambers was Tuesday. Under the Alberta Rules of Court, you needed only 5 days notice, which included weekend days. So you'd get served Friday afternoon with the application for a Tuesday appearance.
It was awful. The Fort McMurray treat, yeah.
The Fort McMurray treat or the Fort McMurray special. And so now having to complete the JCC, it gets everyone kind of cooled down a little bit at the start. That's not to say I haven't had instances where I've had to jump the queue and bring an application to not do the JCC, but it really forces people to start thinking about how do we resolve this absent even that JCC, and how do we work as lawyers with our clients to find big pieces of resolution in that 6-month period. So that's been helpful in a sense. But from completion of JCC to getting a trial, it might be another 6 months, sort of a thing, if you needed to run a trial. Fortunately, I don't have to run a lot of trials. As we know, people don't have money for that. Typically, right. The average person doesn't. So it's really funneling, like, what can we do to use our efforts at the Judicial Case Conference to get as much resolution as possible. And it's funny, you talk about judges, like some are really good at doing the JCCs, and some come in and basically they don't take a pass, but they're more robotic and they're less empathetic through that process. And they'll basically say, this is without prejudice. Can you folks resolve anything? And it ends up taking 20 minutes and nothing really happens, versus some that say, no, here's what we're going to focus on today. I can't force you into resolution, but I'll give you an opinion on this issue. If you can't solve it, we'll figure it out at a chambers application, sort of a thing. And it gets people moving the right way. But anyway, that's a long, far off story from timelines. But Rob, what are you guys experiencing in Alberta on that?
Well, we have a magical process in our bigger centers in Calgary and Edmonton called Family Docket Court. And I love it. It was born of the pandemic. Instead of trying to smash things into court, as Darren suggested, in the olden days on 5 days notice, or now even some months notice, you can get into Family Docket Court, which is procedure court, usually within about a week. And the great thing about it is you don't have to really file anything. It's one piece of paper that's not sworn evidence that just says, here's the parties' names, here are the issues, even if you don't have a file number. And the other lawyer or the self-rep can show up before a judge, and both sides can suggest what should happen next. Whether you need to go to a chambers appearance, whether you need to go to an extended hearing, or even a trial, or whether some form of mediation is appropriate. And that justice at that first appearance can make directions on what needs to happen next. And I must I don't know if you or anyone watching heard me, I was just typing, because this is set up in front of my computer. Darren knows I've been in a furious email battle all day with one somewhat challenging lawyer just trying to get a date to set a procedural issue for a hearing that's already set about a month and a half from now. And I want to add another issue, and he's making it very challenging for me to do so. But we still like that we have this procedural court. In terms of actual timelines for trials or other things, I think trials, depending on their length, are still a year to 2 years out. But the courts with this new procedural piece are really pushing people into more alternative forms of dispute resolution and just making it mandatory through specific orders on specific files, regardless of what's in our court rules.
I have a question here about parental alienation from Trish, who's asked a number of really good questions so far. But the issue of parental alienation, I think there's a theme of thought right now, and I don't know the whole background of it. I don't pay attention to this that much. That parental alienation is not real, in the sense of it was apparently developed by a psychologist who has some discredit to his record. This is many years ago, so I don't know the full history there. But I think there's some that think, and I'm just talking from a legal perspective here, that it's not a valid concept or issue to be raised in a family law proceeding. And I'll just jump in at the outset and say, at least in British Columbia, it very much is a valid legal concept. It very much is raised in pleadings. It very much is argued. And I don't think any judge would have any issue whatsoever deciding whether or not a child has been alienated from one parent by the other. But that determination must be made only on expert evidence. So you must have that psychologist that's going to give you an expert opinion that the child or children in the family law matter have in fact been alienated. And again, that's an expert opinion that must be rendered. And they would also likely, as part of their opinion, give an opinion as to what the appropriate parenting arrangement would be if there is a finding of alienation. But more broadly on the issue of is this real or is it not, for family law legal purposes in Canada, I'm certain almost all provinces, if not all, it very much is a real thing. It can legitimately be raised, despite whatever you may personally feel about the history of this concept. It very much is alive. But I understand, Trish, you may have some concerns about that from that basis. But I guess just from my perspective here in BC, that there's no dispute in our courts whether or not it can be raised as an issue. But do you guys have any different views on parental alienation and whether it's being eroded as a concept or whether it's very much still valid in your jurisdictions? No opinions.
Robert, I'll let you go first.
Oh, sorry. I was bouncing that to you. I have thankfully not experienced that too much as a formal piece on any files that I've dealt with. I would generally echo Darren's remarks. I think our courts are treating alienation as a much more specialized, heightened classification than just to have folks throwing around that sort of language in affidavits or other evidence to try and get an edge in the parenting. You need expert evidence to do that.
And I can tell you, yeah, and I think it's fair to say it's very similar here in Saskatchewan. I mean, we have some case law where the parental alienation has been raised and the judge has found that there's a problem. Now, whether the judge is willing to give it a label because it is a controversial label, or to say, given what the evidence is, I'm going to order a parenting arrangement to address what I've concluded has been inappropriate behavior by one parent. And so they might shy away from the label because of the medical I guess kind of controversy or the lack of coherent agreement as to whether it's an actual standalone thing or it's just something that's part of other already accepted kinds of problems in the sort of mental health world around how parents can actually cause a tremendous amount of damage to their children.
Okay. On the heels of that question, we have one. Someone asks, if a child has a counselor, it's spelled like a legal counsel, but I'm going to assume it's like a therapeutic counselor. Would they be able to attest, that counselor attest or give evidence of parental alienation? They say due to lack of communication. I'm guessing the lack of communication between the parents, they're unable to communicate. Would the counselor for a child be able to give a determination or evidence towards a finding of alienation? My view would be, at least where I practice, no. Our courts in BC have been very clear. If there's going to be a finding of parental alienation, it has to be that of an expert. And in our province, those that could be classified as an expert in that field, it's quite narrow. Like there's maybe 10 to 20 at most psychologists that are, when I say in good standing, recognized by our courts as having been experts in a number of these cases to be able to render an opinion that there's alienation. So sometimes we see that because people feel like there's at minimum some estrangement, if not alienation. Estrangement meaning the child doesn't want to have a relationship with that parent, but it's uncertain whether that's because of the misconduct of the other parent or the coaching of the other parent leading to that estrangement. But they don't maybe have the money for the expert, and this is where it becomes really difficult in these high conflict cases. Is to get one of these experts where I'm practicing, and I assume the same can be said in Alberta or Saskatchewan, to get a psychologist to render an opinion that there's alienation. I would think it's a $10,000 to $30,000 report. That's a sweeping range, but I did have a voice of the child report, what we call it here, completed a couple years ago with a psychologist, and the total bill was $20,000. There was not a live issue of estrangement, but it was a high conflict case. So what we see here, I think, is people saying, well, can we get someone else that's maybe a bit cheaper to help us? And the counselor already knows the kids. And I think my answer is no. And I've rarely seen courts ready to accept evidence of folks like that or teachers. I mean, typically they can show up as witnesses, but what sort of weight is given to that evidence? They're not going to be, in this case, I can almost say with a certainty that they wouldn't be able to give an opinion of alienation. But good thoughts. Any different view in Saskatchewan in terms of who can render opinions on those sort of things?
So keeping in mind that because I'm not a litigation lawyer,
Yes.
I'm really going to speak to this from a slightly different perspective, right? So even in collaborative cases and mediation or trying to settle outside of court, lawyer to lawyer negotiations, these kinds of really difficult issues still come up. And there's two parts to it. One is whether or not it's necessary to prove it, right? I might believe that my children are being alienated against me because that's what I'm experiencing. Or alternatively, I might be engaging in behavior that somebody else might think is alienating, but it's because I have concerns about the other parent, that I think that there is a risk of harm to the children. And so I may be reluctant to have the children go and spend time with the other parent, or I'm trying to limit contact in some way out of legitimate concerns, but somebody else might label those as alienating behaviors. And so the first question that we're asking is it necessary to prove whose version of events is correct? Because if somebody believes that it is necessary, then my next question is, well, once it's proven, let's assume you are correct and you're able to prove it. And whether it's from a expert or a counselor or, however it is that you're going to prove it, if you do prove it, what is your expectation of what's going to happen next once it's been proven? Because I think sometimes people would benefit from thinking through the various steps, almost like a choose your own adventure, like a flowchart, right? So if it can be proven and it is proven, then what? What are your expectations of what will happen? Kind of back to our earlier observation that the law is very limited in terms of what it actually can accomplish. So then let's also think about, well, if it can't be proven, but you still have these concerns, what are some practical steps and other options that are available to you, but within the parameters of what would be allowable? Because I know sometimes people will be like, can we just get rid of the other parent? And the answer is no, you can't just get rid of the other parent. But think about from a practical, common sense perspective. What are some things, if safety is your concern, what are some ways in which you can maximize safety? If the relationship building part is your concern because you believe that the other parent has damaged that relationship you have with a child, what are some other ways in which you may be able to try to invest in that relationship? A big part of the work that I do in our out of court kind of processes is trying to sort out what's within your control and what's not. Because a lot of times the things that are outside of our control is what we're focusing on, and it increases the frustration because it's like, well, why can't we do something to make the other parent behave differently? Because it's outside of our control. So what is within your control to be able to make the circumstances you found yourself in tolerable, safe, and with a mind to being able to move forward in this new lifestyle of being separate and apart?
So we do on our podcast, Rob and I, Divorced and Done. We what we typically do is we answer listener questions. So we get a ton of these questions, and we work them through steps. So you said a choose your own adventure, Charmaine, which was cool because we have one adventure path that you can choose, and it's called the Divorced and Done steps. So you get one path. Like you as sort of akin to other experts or whatever in their field. We're not experts per se, we're just lawyers, but
nobody's special. There is one path. Yeah, that's
there
great.
Is one path, right? So what we do is, and I'm curious your thoughts on this, right? Because we haven't actually canvassed other lawyers for their thoughts on this, because frankly we don't really speak to other lawyers, and we don't. I mean, we speak to the public through our podcast, and our work on this platform is speaking to the public as well. But we say there's 6 steps to becoming divorced and done, and you must work through them sequentially. No skipping steps, and it allows you to orient yourself through the process. So step 1 is living separate and apart and making sure everyone's safe. And when we say separate and apart, we mean 2 separate residences. For various obvious reasons, it's tough to work through the rest of the step if you're eating at the same kitchen table while letters are going back and forth between your respective counsel. It's good to live in 2 separate residences. It's also good to be safe, so any of those protection pieces fall under step 1. Once you're living separate and you're safe, then you move to step 2, which is how are we going to parent our minor children, assuming there's minor children. That's your sole focus at that point. You have 2 houses, so how are Jimmy and Sally, or whatever your kids' names are, how are they spending time between the 2 houses? How are you scheduling those things, and how are you working together to make sure your kids are put first? Stemming from that, step 3 is child support. Now you know where the kids are going. Child support's rather formulaic at that juncture. So we don't spend a lot of time talking about that piece. And then step 4 is dividing your stuff and your debts. So how do we divide our family property and our debts? Step 5 is spousal support, because that's sort of tied to step 4, right? We can unequally divide property and debt, but we put that afterwards as the last consideration, because we want to deal with the most important stuff first, right? The kids. Once all those substantive steps are done, last step, step 6, is being divorced and done and submitting your divorce package for filing and completion, subject to, of course, living separate and apart and meeting the jurisdictional requirements. Or if you're not married, then just getting a final consent order or separation agreement. So if you follow those 6 big steps and you follow them sort of in order, you don't start the process by going, oh my God, I have to pay spousal support. Let's think about that. I don't care where my kids live. I just want to worry about spousal support. No. Focus on the most important pieces first. And so that's our adventure path. And that's what we just keep. People email us all the time. People can send us these questions on this format. The same as, hey, you're at step 2. Let's not worry about step 3. Let's worry about step 2, sort of a thing. But maybe we're oversimplifying things. Maybe we're just dumbing it down way too much.
Well, what I'm hearing you describe is something to help keep things simple for people. And it's really interesting because you're describing a very linear process. And whether this is, I know that we're not really supposed to say that there could be gender differences, but I wonder, I think about it in a much more circular fashion, right? Because how we're going to be in separate and apart homes to be able to parent our children, well, we need to be able to have a sense of who's keeping the family home, or are we going to sell that family home, and we need to be able to have a sense of budget, which comes from your child support, as well as whether or not there's a spousal support entitlement. And so though those are still 100% still the steps that I would work through in my clients in a mediation or a collaborative setting, it would never be linear in that same sense, because the way that I would engage with it is about how there's like almost, I have this visual of dominoes, right? It's like they all are connected in some way, and the fluidity that comes with that is really important to consider. We often will also embrace the idea of review periods, which again is a little bit different than when you're going to court to get an interim order that says, all right, this is what you're doing, good luck. And maybe you return for a final order, but as we know, a lot of people have spent all their money on that interim order, and then that's what they're working with. Of course, I'm curious if the two of you have ever seen this, is that I often have people who come into mediation long after maybe not long after, but after they've received their court order, and they don't like their court order, like neither of them do, or it's simply not practical. So now they come to mediation and say, okay, what could we agree to that will work for us? Because this judge, who, surprise, surprise, doesn't know us, doesn't know our children, doesn't live in our shoes day to day, has provided this, arbitrary, not entirely arbitrary because it was based on evidence, but this order, this is how thou shalt parent, and it's not going to work for us, so we need something different. And so that's a little bit different from your question there, Darren, but it definitely, those are the steps to go through. But I would, in my Choose Your Own Adventure, we're talking about them not necessarily in a linear fashion.
It's one and the same in the sense of you just give people more of an option in terms of how they go about their adventure path. We just force them down our path, and
right.
Either works or it doesn't, right?
Yes.
But part of this as well is from
winding.
Marketing, right? It's about a bit of this is business as well, and we should be very clear about that. When we see, I've thought a lot about this. I know Rob has as well, and I'll turn it over to him. But we see a lot of firms marketing themselves, family, any litigation service, as boutique to that client, and we will custom or tailor make something for you. And if you think about that, almost nothing we buy or consume now is tailor made for us, right? We buy clothing off the rack. I buy a house that looks similar to my neighbor's. I buy a Toyota car. Millions of other people own a Toyota car. Almost nothing I own is tailor-made for me. And now I'm about to buy this very expensive service from this professional, and they're saying they'll tailor-make it for me. But if I want something tailor-made, it's going to be awfully expensive, right? I want a tailor-made suit. Maybe I can afford that. Probably not for the average person. So how can I afford a tailor-made divorce for me, where my legal warrior is going to do battle for me, and they're going to tailor make something for me? That sounds so good. And so the thinking of divorced and done or step, right, is that this is a package. You buy the package. No one buys it. It's just how we answer questions on our podcast, totally free. But this is not, we're not tailor making anything for you. You can follow these sort of steps, right? This is the Toyota, right? We don't make Ferraris on Divorced and Done. It's a Toyota, because we all buy Toyotas or Volkswagens or Hondas. And because I raised that in a little bit, one of the questions here is how we keep costs down. one of the ways you keep costs down is not getting caught in the weeds and thinking that you're the only person that's ever had this instance come up in your divorce. It's terrible, whatever, the breakdown of your relationship's terrible, no doubt. There might be some really nasty aspects to it, but there's really, pick your big buckets of issues that need to be solved. We have 6, could be 8. They're all sort of the same, and if you work through them and not treat it like it's unique, really what people want is they want to be done. They don't want their divorce to become their identity. And if it has, they've really lost sight of, I think this is not legal thought at all, they've lost sight of really what life's about, which is you don't want to spend 8 years spinning around in a circle, right? Rob, any different thoughts on that? I've just kind of opined and waxed poetic on nothing.
No, I think and I'm sorry to not really opt out of this conversation, but I agree, as we've discussed so many times in the podcast, with everything you've just said. It's our shared goal to move people through this process as quickly as possible. To pick up something Charmaine said on the notion of people finishing their matters, having those final orders, then coming back and going, maybe this isn't quite right for me. And one thing you and I have talked about, Darren, one of the best things I say to folks, even if we've gotten a deal, even if we've come through litigation, whatever it's been, if they're still having trouble talking to each other, I don't want to say you need an arbitrator or you need a parenting coordinator or a prescribed process necessarily, but you need a guided conversation, potentially, if things have been really hard, to keep it moving forward. And I guess bouncing that back to you, Charmaine, that's really perhaps those pieces once you've moved through your process, whatever.
Yeah, I mean, absolutely. Like, it's 100% about communication, right? And everything is on a spectrum. So you're going to have some people that they both have recognized that their spousal relationship has come to an end. And there's just really no real emotion there. They just one day are like, yeah, you know what, this isn't actually working for whatever reason. And they both just, want to be really practical and follow the steps, and away they go. And they can continue to communicate effectively around their children because they always did. It was just that their relationship had an expiry date and they're okay with that and continued. Then on the other end of the spectrum, you're going to have those high conflict people, or those people where there is coercive control and there's all sorts of really, really difficult dynamics. They're probably never going to resolve their communication issues. And instead it's going to be back to what's within your control, and do what you can for the length of time that you are going to have to co-parent. And of course, we always, as family lawyers, sort of joke about the fact that you're going to be stuck with each other your whole life. But the reality is, at some point, your children do become adults, and as adults, they will make some of their own decisions about how they engage in relationship with their parents. And though you might still find yourself sometimes at, both at the same wedding or the same baptism of your grandchild or something, you can really limit to basically no communication with your ex when you're on that end of the spectrum. But the communication thing is really what becomes the biggest issue. You can divide your property, like just use your common sense, make the list, figure out what the fair market value is, what is your debt, and this is your net value. You're going to be sharing who wants to keep what should be sold, and maybe there's even something that you want to continue to hold jointly for the benefit of your children. Of course, RESPs being kind of the number one thing that is often identified. Set your support based on the guidelines and figure out your parenting arrangement. And it's really interesting, Darren and Rob, you talk about your Divorce and Done podcast. So I'm in the midst right now of just doing a series of TikTok videos on what I refer to as the 10 steps of getting a divorce in Saskatchewan. So they're not 6 steps, they're 10. And I think as I'm hearing you talk about your Divorce and Done, it's very similar in terms of the thought process of to say, and I mean, I start with step 1 being, are you sure Like, have you gone to counseling? Are you sure that you want
Yeah.
to have this relationship come to an end, right? Think about that. And if you haven't tried counseling, go do that. And many people don't realize that that's even a requirement under the Divorce Act for us as lawyers to raise, to say, have you considered reconciliation? By the time people come to see us, usually they have been like, yeah, that just did not work. But still, it's something to consider. And then from there, some of those practical things like the ordering of the marriage certificate and each of those substantive areas of law that you've already talked about. So I think as much as we might sort of talk about it differently as far as the linear versus they're all kind of connected, at the end of the day, I think we're like-minded in wanting to provide tools for people to simplify. Like you said, Darren, they're not the first people to have gone through a separation and divorce. In fact, the statistics consistently from the beginning of, whoever started to collect statistics, hover between 45 and 50% of long-term relationships separate. You transition into, so it is, just as common for you to separate as it is for you to stay together for the most part, right? So it doesn't have to be as complicated as sometimes it is made out to be. There's certainly complex situations. You own a family business, or here in Saskatchewan, our biggest complex situation comes from the family farm. Often it's been in the family for generations, and figuring out how to separate that. You can have different parenting philosophies, and man, that's a hard one, because if you're a vegan and your other parent is a meat eater, there's no way you're going to convince them to feed the children a vegan. I shouldn't say no way, but I mean, it's going to be difficult when you have the tension in the values, and the law cannot resolve that for you. So how can we keep complex things simple, and recognize that even, people can't afford to get the customized Toyota. Is that even a thing? Can you get a customized Toyota? I don't know. They have to, get what there is, but how they might, do they go in through the front doors or the passenger doors? Like, there's just some different ways in which they can engage with it based on their needs.
Are you okay for just a few more minutes, Charmaine? I saw you got into your vehicle. I don't know if you have to. Are you going somewhere?
You know what? I totally am. Yeah, the only reason I went in my vehicle is because my phone battery needed charging, and my charger in my office wasn't working. So I was problem solving in the moment. I'm like, I know it'll charge in my car. So yeah, I'm totally good. I know that was a weird thing that I did there, walking through my parking lot.
Am I right? Is your profile, you're a mother of 11 children? Is that correct?
That's correct. I am. I have 6 boys and 5 girls.
Okay,
Wow.
because I was going to say that would make sense if you had to get in your car suddenly to go do something for or with one of your 11 children. That's quite a full house.
It is. So I have to say they're 20 years difference. So my oldest, who's 30 years old, so now you know how old I am, she actually already has 2 children. So I'm a grandma as well, and she's expecting her third one here in July. But my youngest just turned 10, so they span the 20 years. So they don't all live under my roof at the same time, though many of them come in and out on a regular basis.
That's
Christmas
incredible.
and Thanksgiving must be full events.
Oh, it's very noisy and very chaotic, I can tell you that. So you have to go in with expectations that are manageable, just to be like, it's okay. This might not work out the way. And I can never, I have this very complicated system of trying to label presents so that nobody knows until the day that they're given it. But then it means that I'm often messing it up, and I see someone opening something, and I go, whoa, 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 hold on, that's not for you.
Okay, from the very macro. Sorry, go ahead. From the very macro, our discussion on theory of resolving cases and steps and adventure plans, to maybe the more specific question on parenting. Question is, when deciding on how to come up with a parenting plan, how do you deal with a parent that drinks alcohol a lot? Thoughts on this, guys? Rob, why don't you start?
I would suggest, as we've talked about, dealing with alcohol issues, drug issues, can be challenging, and that if you want to press those as parenting issues, might make your case litigated more quickly. But as we say as step one, it is imperative that everyone is safe. And if someone has an issue with children, obviously approaching them about that issue, being realistic, is that issue actually impacting parenting, or are you just raising that issue to potentially amp things up? To be really clear on what the reality of those drinking issues are, and if they continue to be a problem, and continue to be a problem particularly with parenting children, then that may be something that's actionable, or worst case scenario, Child Protective Services may get involved.
Well, and I guess my thoughts on this is that it really depends on what the drinking issue is like. So we know that there are people who are diagnosed as alcoholics, but you would never know it because they're fully functioning alcoholics. So the children are safe with them. They function at work, but they have a problem. And so when they have a problem, but if it's not causing a problem, then that's something to be able to process as somebody who had been in a relationship with somebody who is an alcoholic, right? And often there's codependency that flows from that. So making sure you're getting your own counseling and being able to really separate the, what are they needing to deal with? What are you dealing with? While always making sure that the children are safe. Now, on the other end of the spectrum, when you have people that are, their alcoholism is causing them to be rage-filled, or they're careless, they fall asleep with the candle burning by, the bed, or they forget to turn off the stove, or they're drinking and driving. I mean, those are the kinds of things where setting boundaries is going to be absolutely crucial.
Just on the heels of that, a question about if certain periods of time are not mentioned in a court order for parenting time. So it's silent. The question is, what if the order is silent on dealing with long weekends or holidays? And I'll just jump in at the start. Phone the other parent and say, what are we doing? Rather than waiting for that weekend to come and then being filled with stress about, this is the way I interpret it, but I haven't heard from them, so who knows what's going to happen, and then you're not really actually enjoying you're not present for your parenting time. I'm making an assumption that's maybe how I would think if that was me, going, oh my God, what's going to happen on Monday, or whatever the instance is. I think the best thing to do is, instead of thinking, well, let's go back to court to get clarity on that order, maybe you can solve that and do a separate consent order if you really need to, or you can just make your own schedule between the two of you collaboratively, and run with that. But I mean, generally my experience has been orders tend to be fairly comprehensive. It should be fairly clear in the order itself, like what the time is going to be from household to household. There shouldn't really be gaps in it. I'm not saying that's not the case, but Charmaine, any other thoughts on that piece?
Yeah, I agree 100%. First step, talk to the other parent. And if you don't have that kind of co-parenting relationship where you could talk to them, then, another great option is if you've engaged a parent coordinator. Now, of course, I don't know the other jurisdictions. In Saskatchewan, you can just contract a parent coordinator, or if the other party is not agreeable, you can seek a court order so you have a parent coordinator. And for people who maybe aren't familiar with parent coordination as a service provider, it's a 2-year appointment, at least in Saskatchewan, or a 2-year contract, which the parent coordinator is, under our legislation, is given certain powers that they can enforce decisions. So they really try to help the parents figure things out. But in the event that the parents can't figure it out, and this is a classic kind of an example where it's like, well, our court order didn't really say what happens on this random long weekend, what should we do? The parent coordinator can kind of look at it and say, oh, well, this is what you're going to do, and impose that. Now, if you don't have a parent coordinator and you're not able to talk with the other parent, then what the court order says in terms of, if it's supposed to be every other Saturday or it's like week on, week off, whatever it is, then my opinion, and curious as to also what Rob thinks too, is that you just have to follow what it says. It means that it's basically your order is blind to whether there's holidays. So too bad. Now you're going to have to create your holidays in a different way, because it's going to just continue in the rotation set out in the order regardless of.
Yeah, I tend to generally agree. I prefer the notion, as Darren says, pick up the phone. Work it out with that other person if you can't. But otherwise, yeah, you do have an order, and it does bind you. And I think we have the biggest trouble. I know where folks have an old order. They've gone off it. They've done something totally different, sometimes for years at a time. Then someone gets upset and says, we're not doing that anymore. Back to the terms of the order, where I don't care that you've had shared parenting, other parent. I'm restricting you to 3 hours every other Sunday, as our order from 4 years ago says.
Maybe our last question, because I think we should all go enjoy our weekend rather than talking shop. I say us, including the people in the chat room right now. This is an interesting one. Scientician asks, how do you feel about alternating years for custody? My ex wants to move provinces for work and trying to find a mutually agreeable solution. I'm going to be brutally honest. I've never seen such a thing. I've never seen such an order. I've never seen such an agreement. Charmaine, have you ever seen that?
Well, I have to say I've never seen the years, but I have seen months. And in a similar type of fact scenario where there was a move that was happening and it was obviously not going to be in the children's best interest to go back and forth, every week. And so they made an agreement around months connected to the school year. So the first, term of the school year with one parent, then the second term of the school year with the other parent. And then I don't remember what they did exactly with summer months, but, and of course these parents though worked really, really hard to make sure that this was a workable arrangement for their children. So it wasn't like they didn't ever have contact with the other parent during the months that the children were living with the, different parent, because they would facilitate other kinds of contact, and they had various different things that sometimes, they might go camping or whatever. They really thought outside of the box because their focus was what was going to be best for the children, not what was going to be most convenient for the parents, but knowing that the children needed consistency. They needed not to have to travel constantly because that was going to be interfering with their social group and their schooling and their extracurricular. They even worked cooperatively with the school divisions so that they could ensure that the children were not going to be sort of mismatched as they moved from school from one term to the other term.
So were they changing schools on a monthly basis? Like alternating?
No, not on a monthly because of, so in this example, it was a term, like a whole term. So from September to Christmas time in one school and then in the other. Now, there was this is reminding me of a different family where they actually had the children in just one school division, but the other parent homeschooled following the same curriculum. So when they were it was more of, I don't remember what the extended, transition was, but it was more than a week on, week off. But because it was also different jurisdictions, rather than having their children participate in two different schools, they just worked with the first school division that the children were already part of to be able to make sure that the parent that lived elsewhere was able to homeschool using that same curriculum. And so it was very seamless for the children, as much as it could be seamless, because you're still going to be away from your social group during that time.
I would think the impact on children in that sort of situation would be heavy, regardless of how well those parents get along.
And the parents would have to get along with
Absolutely.
them well. Like that's not a high conflict matter. They're quite collaborative.
Well, exactly. Exactly, that would just never work for a high conflict family. And the question of whether any kind of arrangement like that is just so outside of kind of what the norm is, whether it's the best arrangement for the children or not, or is this just really supporting the parent that wants to move somewhere, right? Is this just being creative for the sake of supporting the parent who is? Now, sometimes parents have to move, though. So if they're an RCMP officer or they're in the military, or there are sometimes reasons why a parent does have to move, and not just because they, met somebody online and they're, going to a different country because now they're starting a new life. I mean, there are circumstances that really beg for some real creativity, and other circumstances where it would, be good for the parents to just take a step back and say, okay, hold on. Is this my own desire that I'm sort of going to be putting my children in a bad set of circumstances just because this is something that I want?
Well, thank you very much, Charmaine, for you were the impetus for this, and I really appreciate you doing that, because actually Rob and I have periodically done lives, but not very frequently. I sort of, when I got on this platform, initially I was sort of gung-ho about them. Not that I don't like it, but for whatever reason it had fallen off my to-do list. And this was really fun and sort of rejuvenated my energy around doing this again. I don't know about how you feel, Rob.
I think so. I think this was great. And I think maybe, Darren, you and I will talk about it. Maybe we need to have Charmaine on the podcast to come talk about particularly her arbitration role. Because we love talking ADR.
I would love to.
Litigation.
Actually, I'm donning some swag. That's a
nice looking T-shirt, Darren Schmidt.
Nice, nice.
Yeah. Oh,
good promotion. Well, thank you, gentlemen, for accepting my invitation. This was so much fun, and the hour went by so fast. Thank you for everybody who's still on the live that joined us, because you're what obviously makes this interesting for us. So I'm sure the three of us could entertain ourselves pretty easily. And hopefully we'll get a chance to do this again. And I would love to be on your podcast. And so don't hesitate to reach out. And for anybody who's on the call from Saskatchewan, commonsenselawyer.com, feel free to reach out to me. I'm always happy to talk to people and give them some information and help them get off on their journey into the next chapter of their life.
I thought about, when I saw your message to me, I thought about that great song by the Guess Who, Running Back to Saskatoon. Just fabulous.
Aha, yes.
Anyway, you
I know, that is awesome, isn't it?
Okay.
Okay,
Thanks,
you too. Bye-bye.
Thanks, everyone. Have a good weekend.